their denial letter was kind of odd, and it was like, well, now we think you could sit at a desk all day. And her response when she called me and said, listen, I need some help because they're now saying I could sit at a desk, do a job 40 hours a week. I was never able to do that. She's had multiple neck and back surgeries. She went through hip surgery. She's in pain all day long. And she said, I've never been able to sit for long periods. So they had a vocational review done by Standard's Voc expert, but they had all the wrong information. So we had to hire our own vocational expert to give an opinion as to, number one, that they had the job description wrong in the first place. She's never been able to do sedentary. She still can't do sedentary work because her condition hasn't changed. Actually, it's gotten worse over time. And then, we sent her for a functional capacity evaluation also so that we can provide some objective proof showing that she, couldn't sit for long periods, stand for long periods, all the things that would be required for a sedentary occupation. So we really had to revamp her whole claim because Standard had it wrong from the beginning.
Hi, I'm attorney Greg Dell, joined by attorney Rachel Alters. And Rachel, we're going to talk about your recent appeal victory against the Standard. Standard is one of probably the mid-sized disability insurance companies. They sell group disability coverage and individual disability coverage. And in these videos, we like to talk about why the Standard made the denial in this claim, what you were able to do to overcome that denial, and then provide some tips for people so that they could either avoid a denial or be in a better position to help reverse a denial. So give us the background of this case.
Okay, so my client is a nurse, and Standard did pay her. They paid her for 24 months under whether she could do her own occupation. When the definition of disability changed after the 24-month mark to can you do any gainful occupation, they denied, which they often do.
Is it standard for the definition of disability to change after 24 months?
It is in most policies. I've seen very few times I see it as a 12-month ONOC, but most of the time, 99% of the time, it's 24-month ONOC definition. Then after that, it's can you do any gainful occupation that you're, trained to by education, training background, all of that. So they had her as her ONOC as a regular RN, a medium duty nurse, which, you as a nurse on a floor in a hospital, you're lifting patients, you could be lifting up to 200 pounds, you're on your feet all day. However, they had her occupation wrong. She was a nurse, but she wasn't doing any type of physical labor. She was a nurse that was working at a desk all day in a sedentary position, and she was checking in patients at a doctor's office. So as they were paying her for the first 24 months, they were using this incorrect version of her occupation. And then when they denied her, they're like, well, we think you could do a sedentary job now, when all along she couldn't do her sedentary job that she was initially doing for the first 24 months of the ONOC period. They should have been assessing her as could she have done a sedentary job, and they didn't do that. So their denial letter was kind of odd, and it was like, well, now we think you could sit at a desk all day. And her response when she called me and said, listen, I need some help because they're now saying I could sit at a desk, do a job 40 hours a week. I was never able to do that. She's had multiple neck and back surgeries. She went through hip surgery. She's in pain all day long. And she said, I've never been able to sit for long periods. So they had a vocational review done by Standard's Voc expert, but they had all the wrong information. So we had to hire our own vocational expert to give an opinion as to, number one, that they had the job description wrong in the first place. She's never been able to do sedentary. She still can't do sedentary work because her condition hasn't changed. Actually, it's gotten worse over time. And then, we sent her for a functional capacity evaluation also so that we can provide some objective proof showing that she, couldn't sit for long periods, stand for long periods, all the things that would be required for a sedentary occupation. So we really had to revamp her whole claim because Standard had it wrong from the beginning, even though they did pay her for 24 months.
What type of doctors was she treating with?
She had multiple doctors. So when she first called me, she had still been seeing her surgeons because she had back surgeon, neck surgeon. She had a surgeon that performed hip replacement on her. And then she'd been seeing a pain doctor who had been managing her pain, where she would go get injections on a regular basis, and her primary care doctor as well. So she had multiple doctors all on board with her not being able to work. But Standard basically just ignored the records. They ignored what the doctors were saying because they had their own peer review, physicians review records and give it an opinion that, hey, we think she could sit at a desk now.
But why would Standard listen to their own doctors who never examined her
Yeah.
over the multiple doctors that have examined multiple times your client?
Well, that's a trick question because they get away with it
Okay.
because it's inexpensive. And they know if they hire their own doctors to review records, they're biased and they're most likely going to give an opinion, no matter what the records show, that this person is able to go back to work. So there's multiple reasons they do it. It shouldn't be allowed. It's unfortunate that they do get away with that because they should have sent her for an independent medical evaluation to hopefully an unbiased doctor that's going to do an examination and look at her and say, hey, this one's been through the ringer. She's had 5 to 6 different surgeries. She's in pain. There's no way she could be any kind of, full-time employee and be reliable because, she's taking pain medication, which fogs her mind constantly. And so it's, they don't do the right thing. But they do get away with it. That's why you have to call an attorney such as us who know how to get what needs to be done to get your claim reinstated.
A lot of people watching our videos learn for the first time that a disability insurance company is going to either hire their own employees or some other doctor that they may or may not have worked with before to just review records. And more than 90% of the time, they're never going to talk to the claimant, they're never going to examine the claimant, yet the reverse of that is that the disability insurance company, especially Standard, requires you to treat with a doctor who's physically seeing you, touching you, evaluating you, requesting testing and doing everything. But on the other side, what Standard wants from you as the claimant, they don't operate the same way. And so, like you said, they do it more because the law allows them to do this. So they're not violating the law per se in terms of by not physically examining a claimant. Now, they are potentially, and what we prove if we don't win an appeal, violating the law because they're not doing a reasonable review. So there's a lot of actions that Standard can take that leads to a denial, but when it comes to if you were to lose an appeal, that the courts would say, well, the way in which Standard you went upon doing your review, it wasn't a reasonable review. And so, it sucks in the beginning when the claimant gets denied, and a lot of times we win the appeal, like you did in this claim. But when Standard doesn't take the step to examine a patient, and I'm not saying necessarily just because they examine them, they're going to get the right doctor or whatever, because you still have to see the quality of that review that's done, but they're almost making it easier for the claimant to win their case because you always have that opportunity to say, you never even looked at this particular claimant. And your case in particular, there is so much, it's nauseating. Multiple surgeries, hip, neck, back, injections, medicine. Like, you think this person's going to sit, we're in this video for 10 minutes and you're kind of sitting still is, we do it and people do their jobs, but we're not talking about that. We're not talking about your client going to dinner, going to shopping or doing what we're talking about. Now you're saying go sit at a desk for 8 hours a day and maybe you can take an hour lunch and 2 15-minute breaks, which is what the normal expectations are from an employer. And not just physically be there in body, but be there in mind.
Oh, yeah.
So how could your client possibly be there in mind and focus? And now you're a nurse. So are you making medical decisions or treatment of what could affect someone's well-being?
Absolutely.
It's crazy
Right.
in those certain jobs. It's not like you're not to knock librarians, but it's not like you're the librarian or the check-in desk where, okay, I made a mistake. You don't make mistakes as nurses.
No, she in her job, she was responsible for checking in patients, calling patients, asking them what their symptoms were, getting them scheduled for surgeries, things that if you make a mistake, it could be somebody's life, and that's a big problem.
Well, it's great that you were able to get this claim reversed, and I know you've handled hundreds of claims against the Standard. They do often do one of the more detailed denial letters, so it can be one of the more challenging disability type denials to overcome, but the appeals are only as good as the person who, the denial letters are only as good as the person who wrote the denial letter, and some are better than others in terms of being more thorough in what they do. And a lot of times though, no matter what, like we say, it doesn't matter so much what that person at Standard thinks who's evaluating the claim. If they send it out to their hired doctor and the doctor says not disabled, you could have 12 doctors treating you who say you're disabled, but if they have one who says you're not disabled, it's almost like that Standard employee is trained to say, well, I got to go with the doctor I hired because all of your 12 doctors must not be telling the truth, which is absolutely bizarre. But look, it doesn't mean you can't win these things. You win them all the time. We win them for our clients all the time. And here, you did win, and it was reversed, and it's more of a norm than not the norm for us to win these appeals. So congratulations on winning this case. If you're someone with a Standard, who has a Standard short or long-term disability insurance policy, feel free to reach out to Rachel or myself or anyone on our team. No matter where you live in the country, we're available to provide you with a free consultation. We look forward to speaking with you.